Our last case for today is People versus Burkman. This is a 20-minute argument with 10 minutes for amici ACLU. Mr. Bowman, I have you up first. Is that correct?
Yes, Your Honor.
As you know, you have 2 minutes of a free fire zone. I believe that you are going to reserve time for rebuttal, but you are sharing time with Mr. Amadeo.
Yes, that's right, Your Honor.
So you'll coordinate and keep track of all of that yourself.
I'll do my best, Your Honor. Good morning. May it please the court. Tim Doman on behalf of Jack Burkman, joined at council table by Scott Grable, as well as, Your Honor said, Bill Amadeo, who is representing Jacob Wohl, and I will be dividing my time with him. So just to jump right in here, I think the Court of Appeals decision is kind of a classic example of the maxim that bad facts make bad law, right? I acknowledge that the defendants in this case are not sympathetic. I'm not here to defend the motive with which the robocall was made. The word reprehensible has been thrown out throughout this litigation, and I don't think I'm here to push back on that. But as I've often heard justices of this court say, we're here not just for this case, but for the next 100 cases coming down the pike. And so while I think it's easy and maybe cathartic for this court to want to punish our clients, I really do worry about the seeds being sown into our jurisprudence if the Court of Appeals analysis stands. And what I think this really boils down to is that MCL 168.932A is a statute that originates in the 1840s, and I think it's just too blunt of an instrument to be used to police disinformation in our elections in 2023. Obviously, we've raised several arguments, sub-arguments. I think some are probably more compelling than others to this court. So I really want to focus on what I see as the dispositive issues, and that is the correct definition of corrupt means or device, as well as the void for vagueness doctrine under the constitutional arguments. So starting with corrupt means or device, what the Court of Appeals has said and what the prosecution has repeatedly said was, well, corrupt just means wrongful. I have yet to hear an articulation of how a wrongful standard would work in practice beyond the facts of this case, especially if we interpret corrupt means or device to include false statements. And I think one word in the statute that the prosecution has really avoided talking about is the word influence, which, as we wrote in the briefing, I think has to mean influencing not just the decision whether to vote, but whom to vote for between two or multiple candidates. So if the statute reaches false statements, it's not just limited to false statements used to deter voting. It reaches false statements used to influence voters on whom to vote for, which obviously implicates a lot of political speech at that point. And I think that shows why corrupt means or device does not mean false statements standing alone. It has to be speech plus conduct in the same way as bribery and menace. And I think really a lot of this uncertainty about what is a corrupt means or device dovetails with the constitutional void for vagueness argument. Because I don't believe that a reasonable person would be on notice that corrupt means or device refers to false statements, and or even that it means wrongful in general. I especially reading the entirety of the election law, there are sections that differentiate between corrupt conduct and malfeasance, malfeasance being a synonym for wrongful. The other point is that the prosecution has also argued that even conveying truthful statements can be criminal under the statute. Should a reasonable person reading the statute know that? We used the hypothetical, I think a couple times. I think the ACLU piggybacked off of it, but let's say that right before the 2020 election, there had been a robocall release that warns about the dangers of COVID-19 and says, don't vote in person, vote by mail. I don't see how that's not criminal under the position being advocated by the prosecution in this case. So I think at the end of the day, corrupt means or
But under your
device.
hypothetical, I understand there's like a fine line here, and I understand what you're saying. Under that hypothetical, is that designed to deter voting? The latter hypothetical, don't vote, be careful.
I think it would be designed to deter in-person voting, right?
Okay.
So,
And so I'm trying to, I understand the argument about vagueness and all that, and I hear you. One thing I'm trying to figure out, how do we square sort of your clients being on notice? We know, we've been asked to take judicial notice of the proceedings in Ohio. Does that show some sort of awareness of wrongdoing or something that certainly one could potentially call corrupt means?
I will say about the Ohio pleas, just to remind the court, we are here on an interlocutory appeal from the denial of a motion to quash. So this court is tasked with reviewing the record made at the district court level and saying, was there enough evidence here to bind over? And certainly it's a position a lot of the time where a criminal defendant might learn of favorable evidence after the preliminary examination. It doesn't mean we get to use it in our quash motion. So the remedy is either they could potentially introduce that into trial, or if this court holds that the bind over should be quashed for some failure of proof reason, that we have a new prelim. But I don't think you get to add it in a week before oral argument at the Supreme
Counsel,
Court.
I like to always kind of keep things simple, and I'm just going to ask kind of a more simplistic question. What kind of a call was this? How would you describe it? If I was to ask you just to describe to me, this was a call to what?
It was a call to, under our client's theory, to warn people about potential consequences of mail-in voting.
Okay, so your argument is like a public service call?
I'm not saying that, Your Honor. And as I said at the beginning, we're not conceding what motives were at play here. So really, again, I think the overarching concern here is what rule is this court going to promulgate, and how is that going to apply in other cases? So again, I'm not here to defend the motives of the robocall.
Okay, thank you.
Thank you, Your Honor.
We've had a proposal from amicus in this case to try to do a limiting construction to take care of some of the First Amendment concerns. I would love if you could address that.
Sure, and I think it's true that if there was a statute that prohibited false statements about time, place, manner, consequences of voting, that would be a constitutional statute. We've never disputed that. And under the case law, to have that limiting construction, it has to be fairly plausible, I think is the language that gets used. But I think just reading the statute, on its face, it's not a time, place, and manner restriction. It talks about bribery, and obviously that, not just bribing someone not to vote, but whom to vote for. So it reaches beyond time, place, and manner. So I don't think that interpretation is fairly plausible.
Counsel, you just slipped in a phrase that the ACLU also slipped into their brief. Time, place, manner, or legal consequences of voting. I couldn't find any legal support for that phrase, legal consequences of voting. I see lots of cases talking about time, place, or manner restrictions and when those are appropriate and when they're not. I couldn't find any support in their brief, the cases they cited, or the legal commentators, the articles that they cited. Are you just willing to concede that that's a valid addition to that list?
I'm not conceding that. I mean, I was representing their argument, but I think certainly time, place, manner, that's an easy one. Consequences, obviously, I'm not a legislature. I'm not here to write a prospective statute. So, but I will concede that time, place, manner restrictions would be legitimate. I'm not necessarily conceding consequences, but so I think going back to void for vagueness, corrupt means or device, it's not an everyday term that we use. I think it's only found in one other section of the Michigan compiled law, so it's not as if this is some well-understood phrase in the law. And so I think it's similar to Boomer, to Reno versus ACLU, where you have this really broad phrase without any kind of definition limiting it. And I think one possible way forward for this court I know it seems like it's disfavored, but I think the rule of lenity could come into play here, where I think if there ever was a case where the rule of lenity could come into play, it could be this one. And I think this
Before we get
court,
to the rule of lenity, don't we have to think a little bit about what we think corrupt means under the statute? Or should
oh,
we
absolutely.
sort of give up because it's hard?
And I understand that, like I said, I know it's not the preferred way to resolve this, but I'm just
It's
proposing.
it's an important issue. I don't mean to downplay it. I just don't think we're quite there until we have tried to exhaust our efforts to understand, what the correct understanding of the word corrupt is in this statute, which, by the way, I take a little issue with your history. The statutes, I mean, it did come into Michigan when we were a territory, I think. But actually, we adopted the statute from New York, where it's been in place since 1787. So a version of this statute's been in place here and in New York for almost 250 years. But what do you think of the notion that corrupt might be or should be understood as a term of art?
To be honest with Your Honor, I researched this issue, and there is similar language in other statutes throughout the country. There's just not a lot of case law on these types of statutes, at least that I was able to find. So the possibility that it could be a term of art, I think this court would be obviously interpreting this language for the first time. And I think it could be a term of art, especially when you mix in bribery, menace, and if we're talking about corrupt means or device used in reference to those antecedents, then certainly I think it could be used as some type of term of art.
In the way that Justice Scalia interpreted the related word corruptly in U.S. v. Aguilar, to have a long-standing and well-accepted meaning. It's an act done with an intent to gain some advantage inconsistent with official duty and the rights of others. Like bribery, but more comprehensive, which follows some of the dictionary definitions, I think, of corrupt. Do you think that's an appropriate definition, or you think that's so unclear that we should move on to the rule of lenity?
I think this is a difficult case, to be honest, with Your Honor. I think not only do we have corrupt, we have bribery, menace, and then corrupt means or device, which is a little bit different than just, what is the definition of corrupt. So I think it is a difficult question, and I don't think there is any case law existing that squarely answers it. And I think certainly, as I wrote in the briefing, that we shouldn't incorporate corrupt as it's been defined in misconduct in office, which is unique. So I see that I have 8 minutes left. I would like to get Mr. Amadeo up here.
Amadeo, P76194 for Jacob Wohl. I'm going to make this as simple as I can from my perspective. I think, obviously, our court's read the briefs, heard Mr. Doman. I think this falls into protective speech. I think the Attorney General is prosecuting based on content. When we prosecute based on content, we get on a very slippery slope. This is not obscenity. This is not child porn. It's not defamation. It's not false advertising. It's not a true threat, and it's not fighting words. What we have is a strict scrutiny analysis. We look at strict scrutiny. I go back to my Michigan bar prep days. Compelling interest that's narrowly tailored. Is there a compelling interest in this speech? Absolutely. Protecting voters' rights. I don't endorse what was said, but I do endorse the protection for the speaker to make that statement. This is not narrowly tailored. This was not done in the least restrictive manner. If we prosecute political hyperbole, which is exactly what this is, we're going to have nothing but constant prosecutions from both the left and the right wingers during election time. It simply is a basis of regulating the content of speech, and we can't do that. That's all I have to add, and I'll answer any questions.
Has any lower court done that analysis?
Not to my knowledge, Your Honor.
So how do we get there in this case? As it's currently postured, the Attorney General is only arguing, I think, that the exceptions apply. They're not maintaining that position, are they? Or where do we go from here? You're asking us to reject the two defenses, the fighting, or what were the two, integral to a crime?
True threat.
Yeah, the true threat. Reject those and what, remand it to the lower court to do that analysis? Is that what you're asking us to do?
Well, I would argue the elements to true threat simply aren't met. reaction of the recipient would be one of those. At the preliminary examination, the one complaining witness that testified said he was actually motivated to vote upon hearing this robocall. If we have people that are motivated to vote, clearly we do not have anyone who's been present, at least there's no standing to show anybody was distracted from voting. A true threat would mean you said something that is so imminent that I was terrified to have a course of action. That was not presented by the Attorney General. If anything, the one witness said, and I asked him directly, did you vote upon hearing this? Yes. Were you motivated to vote? Yes. Did this distract you? No. That's what a true threat is, Your Honor. Somebody is going to take a course of action based upon someone saying something. That didn't happen here. Cannot prosecute based on
I
supposition.
appreciate your argument on that point. I'm just, I guess I wasn't really trying to engage you on that point. I'm asking you if I agreed with you on that point, then what? Are you asking for a remand? What is it you're asking this court to do at this point for the strict scrutiny analysis?
I mean, obviously a dismissal, but I think you might be more articulate with that than myself. I think it's a
Are you
pure
asking us to
dismissal.
make the ruling on strict scrutiny for the first time at our level? That would be a bit unusual, wouldn't
I think it's very clear we're asking, what the prosecution is doing, Your Honor, is asking for prosecution based upon the content of speech, and the speech is protected. I think it's a fundamental freedom of speech case. It does have protection.
Would you like to save the rest of the time for rebuttal?
Third time, yes, Your Honor, thank you.
Mr. Mayor.
May it please the court. Phil Mayer appearing on behalf of Amici ACLU of Michigan, as well as Promote the Vote. The robocalls at issue here were a repugnant attempt to disenfranchise minority voters by lying to them about the legal consequences of voting by mail. The Attorney General is understandably eager to see them punished, and the Amici agree that they can be punished. However, in seeking to do so, the Attorney General is urging this court to adopt two dangerously broad First Amendment theories that could not just allow the government to punish the robocalls at issue in this case, but also to censor or punish core protected political speech or entire swaths of protected speech in countless contexts simply because that speech appeals to listeners' fears. By contrast, Amici offer the court a path that both protects voters and the First Amendment. Instead of relying on the broad exemptions to the First Amendment urged by the Attorney General, we urge this court to avoid any collateral constitutional damage by ruling narrowly. This court should interpret MCL 168.932 as applied to a case involving pure speech like this to prohibit knowingly false speech that is intended to disenfranchise voters by lying to them about the time, place, manner, or legal consequences of voting. In turn, the court should hold that such a restriction survives the rigorous strict scrutiny test that applies to content-based restrictions on speech under the First Amendment. At this point, I welcome any questions from the court, but I would like to address the questions you asked, Justice Viviano, about the incorporation of legal consequences.
Does that language come from the statute?
The statute refers to corrupt means, and corrupt means, as you can see, the parties dispute the precise contours of what that could mean. We offer a narrowing construction that essentially limits corrupt means to lies that are within the bounds of what the First Amendment would allow to be prescribed. And lies about the time, place, manner, or legal consequences of voting are within the bounds of what can survive a strict scrutiny analysis. And I know that
because they're within, I mean, let's assume that's true. I'm not sure why, I mean, you haven't really given me authority for that last category, but let's assume that's true. You're asking us to interpret a statute narrowly, so don't we have to somehow connect what you're saying to the statute?
I don't think that, let me first answer your question about legal authority, because you asked that question of my colleague as well. The United States Supreme Court in Burson has said that a generally applicable and even-handed restriction that protects the integrity and reliability of the electoral process itself can survive strict scrutiny. and also referred in footnote 11 of Burson to regulations of speech that interferes with the act of voting itself. So where the language about legal consequences comes from is the legal lies about the legal consequences. What will happen to you because of the act of casting a vote, not what will happen to the polity because of the results
Is
of
there a
the vote.
distinction between legal consequences and consequences?
Yeah, the distinction that we're attempting to draw in that is precisely the distinction between what might happen to politics, to the nation, to the state because of the results of election versus the results of what will happen to you as a voter for the very act of voting.
So if
And
I
lies
say-
about
So
what...
if I say, don't vote for Joe Biden because your taxes will go up, is that legal consequences?
That's not a legal consequence in the sense that we're using the term. We are talking
what if
about
I
things that
say-
happen to you because of the act of voting, not because of the result of the vote. So the result of the vote is who wins the election. What's going to happen to the world when the election is won? The act of voting is a lie that says if you, voter, cast a vote, the government's going to come after you. They're going to pursue you with warrants. There's going to be mandatory vaccination. That's a distinction that is a very real
Does
difference.
it matter if it says if you vote in this manner, in this way? If you vote not in person, this is what's going to happen?
Correct.
Because it's not just a blanket, if you vote, this would be the legal consequence.
I mean, it would certainly also apply if you were being lied to about what happens if you vote, right? If
Right, but that's not, my understanding from the robocalls is that it wasn't a blanket if you vote.
Correct. It was if you vote by mail. Of course, that was occurring in context during the height of the COVID pandemic when any reasonable person would understand that that was likely to at least result in some voters not ultimately voting because of the fear of going to the polls.
What about defense counsel's point that another call could have said, be sure to vote, don't go vote in person, it's not safe, vote by mail, nothing more said. That's fine?
I think that's an important hypothetical because it illuminates what our test can account for that the Attorney General cannot. Because that would not be lying to a voter about the time, place, manner, or legal consequences of voting. There would be no lie there, first of all. And second, it would be about the sort of about verifiable facts for the individual voter.
What if it's a mistake?
If it's a mistaken call or
I
mistaken
understand the
information.
distinction here, but what if it's just a person calls and they give information and the mistake, it's just a mistake in terms of information that's given?
Certainly, a ban on mistaken speech would not survive strict scrutiny, and our test makes sure that mistaken speech would not be criminalized.
Where do you get the false element from in the statute?
Out of the statute, I think it comes quite cleanly out of the language corrupt means or device. The defendant himself acknowledges at page 25 of the brief under his definition that a corrupt means or device includes a scheme to trick or deceive. So falsity is certainly built into the definition of corrupt. And falsity is critical for the First Amendment because one of the dangers of the Attorney General's theory is precisely that it could extend to true or arguably true attempts to deter voters from voting. So, for example, we discuss in our brief the possibility of what if someone had broadcast a speech by Malcolm.
I understand the distinction between the Attorney General and you. I'm still trying to find the foundation of false, which you say comes from other corrupt means. Does the associated word canon help us when they use the word other and other corrupt means or devices? Should we not look back to bribery and menacing to get context to what other corrupt means or devices means? And I'm trying to find where I can find this false out of those words.
Well, again, the defendant's definition, which is sort of obviously more defendant protective than the Attorney General's, includes a scheme to trick or deceive. There's no question that this was a scheme to trick or deceive voters into not voting by mail. So, I mean, a trick or a deception is falsity. So falsity, I think, is built into options, definitions that both parties have authored around corruption. And from our perspective, is a necessary
language and trying to give meaning to it. You're trying to say, well, this is their interpretation, that's my interpretation is better. I'm trying to find it in the statute itself, regardless of what they say or. Right.
And I'm trying to tell you that it is in the statute from the word corrupt means or device, which easily includes falsity. And I'm further trying to say that the First Amendment demands that falsity be built into the test that this court adopts. I'd like to turn to the concerns we have about the broad exemptions urged by the Attorney General. First, the Attorney General urges the adoption of the use of the true threats exemption here. There's two reasons why true threats are inapplicable here. The first is that this would, applying true threats to warnings in which the speaker themselves is neither threatening that they nor some confederate or person under their control or in conspiracy with them will do an act. No court has ever allowed such statements to constitute true threats. We cite a number of cases from across the country, including in the Sixth Circuit, that have rejected that theory, and this court should not break ground by adopting it here. There's also ample argument about whether or not true threats applies to non-violent threats, which you needn't reach as long as you agree with us on the first point about threatening speech. And the second exemption urged by the Attorney General is the speech integral exemption. And this exemption is dangerously circular. The speech integral exemption was born in the Gaboni case, in which the speech at question was pickets. And the pickets were in support of an acknowledgedly, a conceitedly illegal antitrust conspiracy. And any time that the United States Supreme Court has mentioned or used the speech integral exemption, it has always been tethered to underlying criminal conduct. So here, for example, if instead of just robocalls, there had been this same speech being uttered while blocking access to a Dropbox, that would easily facilitate the use of the speech integral. But that doesn't work here, because what we have is speech all the way down. And so using the speech integral exemption here opens the door to the government in the future doing exactly what the Attorney General arguably does when arguing that any speech that deters voters can be criminalized. If you then sort of define that as the crime, and then it's circular, like, oh, you've engaged in speech that deters.
What about the fraud exception?
I see my time's up. Can I go ahead and?
Of course, yeah.
Yeah, the fraud exemption raises the same difficulties that we've discussed about a test that distinguishes between false speech the fraud solves the falsity problem. What it does not solve is the problem of the distinction between core political speech and speech about the time, place, manner, or legal consequences. So false speech, for example, if you look at the Dryhouse or Arneson or Lucas cases that we cited in our brief, those cases involve core political speech about what a candidate thought or how they voted and what the significance of their career was that were arguably dishonest and represented lies, and therefore could be said to defraud a voter from their vote. But the fraud test, because it's just asking fraud, it's not limiting it to fraud about what? About the time, place, manner, and legal consequences. Whereas core political speech, even when false, is protected, and that's what Arneson and Dryhouse and the Post-Alvarez cases that we cite in our brief stand for.
And counsel, before you sit down,
Please.
what about the scenario of the millions of mailers we get? Somebody says, don't vote, they're all crooks. Is that deterring voting? Is that covered by this?
Well, I think that the concern about somebody bringing a lawsuit about that is precisely why it's important that the court adopt our narrow test here, because that type of communication.
But they're probably not all crooks.
Let's accept for the case of argument that they are. The point is that is core political speech. That's the type of speech that courts around the country have said, even if it's false, we have to protect.
But even if it's tied to voting, like you're using that to deter voting, arguably, how does that fit?
I would say that fits into the fact that it is still core political speech. It is still speech about the issues. It is speech about what we think of our polity, of our democracy, whereas speech about the time, place, manner, or the legal consequences, again, meaning what happens to you, the voter, for casting the vote, that is distinguishable, and that is what the First Amendment allows to be regulated.
What if we take Justice Welch's example one step further, and it's all politicians are crooks, and we can't have faith in the election process. There's no point in voting because you can't guarantee that your vote's going to count. Something that kind of edges more into what you're talking about time, place, and manner, but not legal consequence to the individual.
Yep, plainly protected speech in our view. It is really only if you are knowingly lying about the time, place, manner, or the legal consequences, in other words, meaning what will happen to you, the voter. And that is precisely narrowly drawn because of how pernicious the consequences are of having lawsuits about false speech in the middle of an election. The Lucas case that we cite from the Massachusetts Supreme Court, I think, is extremely illustrative here. That was a case where one of the candidates, the lie in question was he had been a criminal defense attorney, and there was an ad that ran that he had earned $140,000 of our tax dollars to represent criminals, and now he wants to use tax dollars to pay defense lawyers like himself to help convicted sex offenders. He filed a lawsuit alleging that his opponent, under a statute that criminalized false political speech, core political speech, saying, my opponent's lying. He ran a press conference. PACs withheld ads that made similar attacks because of the existence of the lawsuit. That candidate went on to win by 200 votes. By the time the courts could sort it out and decide whether or not it fell under the statute, the election's over, the harm is done. And that's precisely why the First Amendment demands a very narrow rule here, is so that there's no sort of plausibility of coming forward with those borderline cases. And the exemptions, the broad exemptions the Attorney General is urging won't solve that problem. The narrow test that we are urging will.
Can I just ask one last question? And you already kind of went over this, but I didn't really follow it, I have to say. You want us to read in false statement into the corrupt means, I think, phrase in this statute. Is that right?
For purposes when we're talking about speech, yes. I mean, there could very well be other corrupt means. There could be blackmail. There could be other things.
I get it, but as it applies to this case, you're asking us, I mean, the statute doesn't say false statement, right?
It says corrupt means or device.
The legislature in other places has prohibited false statements, so it clearly knows how to do that. And so I'm just trying to figure out, how do we get to your preferred meaning of false statement? I know you're reading it that way because you believe it's consistent with the First Amendment. I get that. Sometimes we read statutes, if we have two permissible meanings, we'll read the one that avoids constitutional problems. But we can't just read things, concepts into statutes that aren't there. So what definition of corrupt or corrupt means do I look to, either in a lay dictionary or in a legal dictionary, that puts me on a pathway to false statements?
I mean, again, at the risk of giving you the answer that I don't think is fully satisfying, I would urge you to look at the definition that the defendants provide at page 18 of their brief, which is a scheme to trick or deceive, or a wrongful desire for pecuniary gain or other advantage. That easily, I think, encompasses an attempt to lie to voters in order to trick them into not voting and therefore gain an electoral
Is there a requirement that
advantage.
there's some gain or advantage?
Absolutely. These were political operatives who were attempting to deter voters from voting, and they had chosen voters who they believed would not black voters, no less, who they believed would not vote for their party.
There's no pecuniary gain there, right? They're not being...
Well, the language I read was pecuniary gain or other advantage. So other advantage necessarily means some kind of advantage that is non-financial.
That's pretty broad for a group that's here arguing for a narrow interpretation.
Well, and then, so you ask me where I get falsity from, and then you say, because you want me to, because, Mr. Mayor, you're asking at this court
Well,
to
the whole-
narrowly
the whole
construe
point
what
is
the
the-
scope of the falsity is. So I'm
whole-
saying you get falsity from that.
The whole point is that citizens are supposed to be able to look at this and sort of understand that, and they won't have access to the defendant's brief necessarily. I'm just trying to figure out the ordinary meaning of words, or legal as a legal term of art, how I get from there to what you're saying. And so
Well, as we point out in our brief, because this case arises on an interlocutory appeal, what anybody interested in the law will have access to is this court's opinion. So if this court adopts a narrowing and constitutional construction, those will be the instructions that are given to a jury on remand. Those will be the instructions that people advising their clients in the future will know to use. So we think that such a construction is easily amenable here, and that the necessary limitations to bring it within an analysis that can survive strict scrutiny will suffice.
Thank you.
Thank you.
Thought you were going to drop one.
Good afternoon. Eric Kostusha from the Attorney General's Office, appearing on behalf of the people. With me at council table is the Attorney General Dana Nessel and the Solicitor General Ann Sherman. Voting is at the heart of democracy, and safeguarding voters from bribery, menace, or other corruption is essential to ensure the integrity of the voting process. That's what this statute does. It does not ensnare constitutionally protected speech. Here, the defendants deliberately targeted thousands of black voters in Detroit, sending them calls directly to their phones, attempting to deter them from voting with false and deceptive threats about what would happen if they voted by mail. It was a crime. The law and its application here should be affirmed. Before I begin to the two central points I'd like to make this afternoon, I'd like to begin with my request that this court take judicial notice of the pleas of Mr. Burkman and Mr. Wohl to one count of telecommunications fraud under Ohio law in October of 2022, which occurred after the Michigan Court of Appeals decision was rendered, because the pleas essentially moot the question about whether the evidence was sufficient at the preliminary examination on this question about whether the defendants knew of the falsity of the statements. And it also renders effectively moot the Court of Appeals analysis on the related claims that could this charge lie if their statements were unknowingly false, because the prosecution is not relying on that theory, as there is direct evidence that they knew of the falsity of the statements. So with that,
Did you waive your free fire?
if you want, sure, of course, go ahead, ask questions,
Well, that's
please.
not in the record of this
Trick
case,
question.
so we just.
Well, one of the
want us
things-
to take into account all, can we
Well,
just take it whatever we want, or
Well,
does it have
this
to
is
be
like a
evidence in
motion
this
to
case?
quash. Think about you sitting as a circuit court judge, and you get this question, and they're taking the position that it's plausibly false, plausibly true, and that the evidence is insufficient. And then they plead guilty to a crime on the identical robocall in which they admit to it being deceptive, and they apologize, they express shame and remorse. And so now they're offering a legal theory which is inconsistent with an action they've taken in another
I know
court.
there's legal and factual arguments to be made, but, one thing you could do is dismiss the charges and reauthorize them.
Well, certainly, if we were at a...
If I
we-
was a circuit judge,
but,
that's what I would say.
But if
the
I,
prosecutor.
well, in Wayne, they were perhaps more generous. They would say, all right, well, we can send this back, or we'll just allow that information to be included.
Could remand it for another exam, I
Exactly. We
suppose.
would remand to continue the exam. The reason I raise it, though, is this. This court has interesting questions before it, and I think it's nice to be able to get some of the things that are really not in dispute, or things that are unnecessary for the court to
Isn't
resolve.
it your position that it doesn't matter whether it was true or false?
No,
or
I think that
plausibly true, or are you withdrawing right now?
That's the point, partly about the reason for bringing this forward is no.
Changing your position?
It has developed based on the intervening case law, and in our.
Your position has evolved.
Well, it's based on the Hansen and the Counterman decision, and in our supplemental pleading, we said if this were a genuine warning, it would not be a crime. And in fact, in the reply brief, Mr. Doman, he pointed that out. He said that's inconsistent with the original filing. If this were unknowingly false, if we had their emails, and instead of them saying the things which they do say, which were hijacking this election, and they were gleeful about the fact that there were angry callbacks. But instead, if those internal emails, we pulled back this curtain, and instead they said, we are fearful for these people, we are afraid they will be subject to either arrest, collection, or mandatory vaccinations, we would not have brought the charge. Because,
Let me just say that this vigorous question, at least I'm engaging in some on both, or all counsel, I think, but you said a moment ago, voting is at the heart of democracy, and of course the rejoinder to that is that the First Amendment and free expression and political speech is at the heart of democracy, and so we're weighing pretty big, momentous concepts here, and we're a little worried about a broad application of the statute that then can be used a lot by political actors to try to silence the views of those they don't like, right, that they
Well,
oppose. And so I'm trying to figure out, we haven't heard much about, for example, are you hanging your hat on the statute, before we get to the Constitution, on menace or corrupt means? Or is it all the above? It's like a witch's brew, we mix together?
no,
and have
we've
a
been
crime
consistent.
that everybody...
We've been consistent about the statement about the proposition. In fact, that's part of the opening remarks, is that there are two predicates. There's menace, and there's corrupt means. Each has been alleged. In fact, one of the arguments from, the concurrence from Judge Redford said menace hasn't been pled sufficiently, that there's not enough evidence because menace has to come, the threat has to come from the maker. That was his analysis in the concurrence.
Agree with him?
No. I think that's wrong in this context, because menace in this statute means to place someone in fear.
So if you warn somebody of possible bad consequences, that's a menace?
It has to be a wrongful runs throughout. In part, I know there's been a lot of questions about the origin of the statute. I think it's worth stepping back a bit.
Where's wrongful come from?
Corrupt.
I thought we were
This
talking
is
about
like-
menace. Now I'm really getting confused.
Well,
I'm
but
starting to get a little
cor-
dizzy.
Well, no. Let me say this. The way the statute reads, it says this. It says,
So it is a witch's brew.
no, it's not.
All right.
Bribery, menace, or other corrupt means or device. In other words, bribery and menace have to be also corrupt. They are instances of corruption. They all have to be wrongful. This concept has existed, right? You're right. It's that for a very long time, because there's three things underlying this statute about what's trying to protect voters from voting. They're supposed to be shielded from bribery, threats, and also about interfering with their ability to vote. In fact, if you're looking for an analogy in Michigan law, and we've referenced this in the supplemental brief, this is just like the witness tampering statute. You pull it up, 750-122. Paragraph 1, bribery. Paragraph 3, threats. Paragraph 6, it's interfering with voting. Interfering with testifying. It parallels this statute exactly, and that's not a coincidence, of course. Why in 2020 did the legislature, in the year 2000, did it create that statute? Because where did it exist before? It existed in the common law. The reason that the misconduct in office statute, or the law, is the right point of reference is that is exactly how this arises. One of my favorite books is Criminal Law, 3rd edition, Boyce, Perkins. If you read any of the misconduct cases, it's constantly cited. It talks about the definitions. In fact, the Waterstone case, which gives us the definition from the misconduct in office, just quotes right out of Perkins.
Applies to public officials, not any member of the public.
Yeah, well, I'm glad you say that, because in fact, there are two statutes with this identical language in Michigan. This isn't the only statute that has this language. The other statute is 4.82, which makes, the language is interesting because it's,
The legislature can punish as a contempt and by imprisonment and breach of its privileges or the privileges of its members for giving or offering a bribe to a member or attempting by menace or other corrupt means or device directly or indirectly to control or influence a member in giving his vote or to prevent his giving the same.
well, thank you. That's helpful because
Oh, you
that's,
looked at that statute, but so what are we going to have?
Well, the point, though-
Legislature, we have to be very careful how widely and
No, but
broadly we
this-
define this, because we can't have legislators putting each other in jail over
my
political
point is this,
differences,
though.
can we?
The concepts have to do with kind of officialdom and the core parts of democracy, which is our legislators voting. In fact, I can step back too, because this is a lot of high theory, but I want to come back to the constitutional pieces about places that are safe places for the argument for the people. But stepping back, the reason the misconduct in office is the point of reference is the right one, is that when the electors are coming in to vote, their protection for giving his or her vote at any election, that's the point. It has to do with the mechanics of that voting process. And so that's why the United States Supreme Court, this is really almost under the fraud exception rather than the speech integral exception, but it's still the point, the reason that they've conceded the very language that the ACLU has proposed. They said that if that's what the statute did, it would be constitutional. It arises from the Mansky language. It's really obiter dictum and a passing reference, but everyone knows it to be true, and no one disputes it, really. We do not doubt that the state may prohibit messages intended to mislead voters about voting requirements and procedures. I think it's unmistakable, in my view, that when I tell you, if you vote by mail, the police are going to track down your warrant, they will track down your warrant, that your creditors will then obtain and take action with respect to any outstanding debts, and the CDC may well then, if it's it is, I forgot the exact language of the robocall, but the import was that they were going to get that information and impose a mandatory vaccination.
If you're a registered voter, that's a public record, is it not? Your address, your information?
The information that's available, the preliminary examination ran through this testimony, and the testimony from the expert from the Secretary of State is, it is false. In fact, she said all three statements are false. And the reason
She said it was false, and then by the time she was done testifying, most of it turned out to be true.
No, I don't think that's true, because the point is that it has never happened to her experience, and that law
Oh,
enforcement
that makes
wouldn't-
it false? Because she's not
No,
aware of
that
it ever happening?
the fact that,
Let me just ask you, if you changed from the law enforcement will do this to law enforcement could do this, would there be no charges in this case?
it would be a different case and a.
Would it be different enough that it wouldn't be
Well,
criminal?
because here, I'll step back for the processes, because I think the application answer is necessary.
Because law enforcement could access this database, and in fact, they
If
apparently,
it were a
according
true
to your
statement-
expert witness, they access other databases at the Secretary of State's office, which wouldn't surprise me
If it were a
to know.
true statement, I think it's essential for everyone to understand how the statute operates. You have to have, and that's why I think we started with the request for the taking judicial notice, because the basis of the prosecution is the falsity of the intent to deter and the falsity of either the threat or the corrupt means of the information within the robocall, which they knew about its falsity. It also has to be objectively false. It has to be wrongful. Wrongful is a linchpin under the law. In fact, if you're looking at, like, one of the cases we cited was from the Sixth Circuit cost.
So you agree now we should read false statement into the statute?
No. It's not how it's being, that's not the way the construction of the statute is being run. It is this. The statute is violated. Think about witness tampering, right? It says interfere with the witness. Well, what does that mean, right? It has to have a practical application. This is the common law. It has to do with wrongfulness, right? And the question isn't, did I make false statements about a candidate and when you were trying to calibrate your decision to vote? That's not the kind of falsity. It has to be wrongful with respect to the elector in giving his or her vote at any election. If you read the Court of Appeals opinion, this wasn't even a part of the conversation. Judge Letica runs through and talks about the very thing, which is that this is to protect the integrity of the election process.
When these statutes were enacted, people voted only at the polls. There was no absentee voting. There was no right to vote absentee.
Right, but the concept
So the
is,
statute was, when it was enacted in New York and even in Michigan, was designed to deal with the interactions between people and other people working on behalf of candidates at the polls, right? And so now, as we get further and further away from the polls and absentee voting in advance of the election, is that where some of these problems come in?
It seems to me that in 1850, if I went around on my horse and was telling everyone with leaflets, I'm a representative of the Secretary of State's office. The election has been postponed for a week, and I only gave it to people who are going to vote the wrong way. Would that be a corrupt means or device, form of trick about the procedures of voting? There is no question that this, as applied, is an
Yeah, I mean, I would agree with you. False statement that on the timing of the election that would impede somebody's ability to vote. Does that extend to one method of voting when you're not discouraging somebody from using other methods of voting?
This is in the context, right? This is during the height of the COVID crisis. It's targeting black voters who probably, I'm not sure if the court, it seems to me that there's probably even a heightened fear about the contagion. So if people didn't vote by mail, the entire point of this was to prevent people from voting. That is the inference we've asked the jury to draw if we get to a jury, and I frankly don't think that's going to be a hard sell. In other words, the point of this we know because we have their internal texts. It's not like we have to guess. I mean, frankly, even the guilty plea is unnecessary because, of course, we know why they did this, right? This is very cynical. They were talking back and forth about how to hijack the election for black voters.
By the way, I assume all that's true, that it was despicable and that it was cynical.
But they don't want them to vote.
And that it was done to influence who voted and who didn't vote. And all I'm suggesting is that something along these lines has happened, throughout history. That's why the statute was enacted when the country was founded. That's the whole point. These types of activities have always happened. So the question is, which ones are we going to sweep within the meaning of these words in the statute? And then what are these words going to apply to? If this statute is read broadly, and we give the broad meaning to the terms that you're suggesting, what's not included? It even includes attempting to influence somebody and who to vote for.
The
So if you
three
determine
core,
that somebody has a wrongful, false information that they gave to a voter and trying to persuade them to vote for or
is
against the
not
candidate?
about information gathering for the corrupt means or device. You have to understand each of the words. We have to walk through the entire process of the statute itself. Because the ordinary violations, ones which they have accepted that, I mean, part of the analysis on the constitutional is that you have to not look at fanciful,
it bears
hypothetical.
on, let's just look at this. It bears on influencing an elector and giving his or her vote, or to deter the elector, or interrupt the elector in giving his or her vote at any election held in this state. So it clearly covers influencing an elector and giving his or her vote.
I get that, but
As
of
does the
course-
statute you just referenced with the legislature.
Right, so
And
we
so if
said-
we give the earlier terms a broad meaning,
There's the idea that giving corrupt, making it wrongful, gives it a broad meaning is incorrect. And here's the reason. You walk through it. Bribery, menace, or other corrupt means or device. When is it corrupt to affect a person's ability to vote? Giving false information. This isn't a statute that's designed to stop you from saying things about candidates. That's not what it's about. It's not. The influence piece is clearly related to the bribery and menace. When I say to you, here's $1,000, vote for this candidate, or if you vote for this other candidate, I'll break your arm, that's the problem. But it also encompasses this concept of interfering with voting. Interfering with voting doesn't entail, I mean, it's not, you've given me bad information about candidates, or I think the election process is fraudulent, I mean, is somehow rigged or something. That's irrelevant. It has to do with the mechanism of voting. It's just like, that's why the witness tampering statute, the fact that this was sent out as a robocall and suggests that it somehow had a political character, it didn't. They were fact statements. You can't make false fact statements about the procedure of voting and not be subject. You can say all sorts of false things. I mean, they're suggesting that mundane mendacity is going to be charged. I don't know, it seems to me that I'm paying attention to the political realm. It seems like mundane mendacity is running along as it has in the past and it continues to do. And the idea that somehow this statute would ensnare is totally the kind of fanciful speculation that the Hansen decision eschews, because if we walk through the constitutional analysis, now we haven't gotten there, we're talking about the statute, but this idea of corruption not tracking wrongful, it makes perfect sense. In fact, if you try to take the definitions that they provided about corruption, about being to gain some pecuniary advantage, it makes no sense, because if I bribe you to vote for my candidate, I gain no pecuniary advantage. It doesn't even encompass bribery, which has to be a species of corruption under the statute itself. Wrongful is the lodestone. It is what drives the misconduct in office charge, because these are our electors in voting. So the question about what's going to constitute a violation, it is then going to be often factual specifics, kind of like the obstruction of justice. If you get that statute out, right, it's 750 505. There's no listing. And if you get then the case law, you're going to find 17 different examples. It's not like that exactly. There are 3 core violations. If I offer you $50,000 to vote a certain way, it's a crime. The statements made in getting you to do that is speech integral exception under the Constitution. If I menace you, they say it's an assault. Why if I threaten to smash out your windshield, is that not a problem? Would that be a problem? Well, under menace is going to be place you in fear of some injury.
if I lie about what'll happen if you go to vote, that's a violation, right?
You lie about the procedures. If you post, election's been, let's say, I mean, think about the artificial
We're
intelligence.
beyond that. We're saying if you go there, I lied. The FBI is going to come to your house. I lied about what's going to happen.
There'll be
if you
someone
vote.
lying in wait who's going to break your arm.
Okay? What
Or
if I lie about what's going to happen if you vote for a certain candidate? Why doesn't
that's not about the procedures of voting. This is about
this
giving
says
his or
that's
her
only one
vote.
part of this? That's only one part of the statute. So you just wanted me to ignore the rest of the statute?
No, I think that the
It says
interference
to
part.
influence an elector in giving his or her vote. That's not about the
Right,
mechanics
but
of an
there's
election.
for the bribery and menace, and the question is it corrupt?
No, you just said if I lie about the consequences. So if I say,
No, I said about the procedures, not the
what
consequences.
if I
That's not the
said if
language
you
I'm
vote for
using.
Joe Biden, you're going to get arrested? Is that a violation of the statute?
No, it's about the procedures of voting. What happened here wasn't.
What
who
ties
the
it
ca-
into the procedures of voting? There's different phrases here.
The
One
language
says
of
in-
this says give his or her vote at any election. And the question comes, what would be a fraudulent manipulation under that statute that would cause a violation? Let's take the witness tampering, which says interfere, right? If I say, the jury system is rigged, well, that is a violation of the law. No. What if I told someone, the Green case, they had the person where he said, if you don't show up, it doesn't matter if you're under subpoena because you're only going to be hit with a $150 fine. Giving false information about what would happen if a person didn't appear for the subpoena. It's the same kind of analysis.
But if someone is standing out, a certain distance from the polling location, and they say, if you vote in person, law enforcement is here, and they're looking for people that have warrants, and you're going to be arrested as soon as you go in and vote, you're going to be arrested. Wait, hold on.
Okay.
Okay, so we've got that, and then you have someone saying, if you go in and vote for X candidate, they're going to know, and you're going to be arrested.
Right. If you say that these things are going to happen as a part of the procedure of voting, that is a corrupt means, in my view. I think that's pretty clear. I think if I'm lying to people about what's going to happen when you vote, in the actual mechanisms of voting. In fact, if you look at the one case that has had this issue is out there. It's in Florida. The 2002 case, they had the very same challenge on an overbreadth, and they just walked through the statute, and they said this also, it could be interfering with the election voting process. That's all they said. In fact, they had two-sentence analysis in which they denied the overbreadth challenge. It's Russ, and if you wanted the case cite, you can just look it up, because it's only like a handful of things that cite it. If it relates to the procedures of voting, that's what it is. And it's not because, the statute needs to have that language. The question is what's wrongful with respect to the electors in the same way if we were talking about misconduct in office. How do we know what's going to be misconduct in office? Well, I didn't know that if I did this, it would be wrongful, or, it would be crime. The idea of subverting the ability of a witness to testify at a hearing because you give them false information about what would happen is the same. It's analogous to this, in which if I give someone false information about what they need to have in order to vote, what they need to know, which is time, place, manner, but also they need to know the procedures. And if you say, in Michigan, if you vote for this candidate, you'll be subject to a strip search. Now, that's ridiculous. Those are even bad hypotheticals, because that's not going to happen. But think about this. Think about the next election cycle. Let's say someone uses artificial intelligence and takes Joycelyn Benson and says the polls are going to be extended until midnight. And they only send it to certain places. Is that a crime? Well, no, because that's not corrupt means or device, because it didn't threaten assault. This is about the constitutional process. And if you look at the Hansen case, which walks us through the speech integral exception, I'm happy to talk about this all day, about the speech integral exception. Justice, you asked the question, is the issue preserved about the strict scrutiny and the narrow tailoring? That was the basis of the circuit court's ruling affirming the constitutionality of the statute. We raised that argument in the Court of Appeals. Then we prevailed on speech integral.
I just want to make sure I'm understanding, and you're doing a fantastic job, by the way, but the question I have is, if someone says polls are going to be open till midnight, and the polls close at 7, is that or is that not a crime?
If they knew it to be false, there's no mistakes. There's no honest but mistaken. If I haven't said it expressly sufficiently, the prosecution is not relying on that theory. That part of the Court of Appeals analysis that talks about unknowingly false, it can be set aside. So so if someone says the polls are going to be extended until midnight, and they have an intent to influence, deter, or interrupt an elector, they have to have the wrongful intent, and it's false, and they just know it's false, and it relates to the mechanics of voting, that would be a crime. This is not an unusual part of Michigan law. The reason it's arised and looks unusual is because the threat and the wrongfulness related to something that itself is not necessarily illegal. Usually a threat is, I'm going to break your arm. Well, even if it's a third-party threat, someone else will break your arm.
What if somebody says, hey, if you vote absentee, there's a very strong chance your vote's not going to get counted?
The question about its tabulation and what would happen post-voting is not a part of the procedures for voting. It seems to me that if someone says, the machines aren't operating correctly, or the election is rigged, that's to me like saying to a prospective witness, the jury's rigged. They always convict people from Northfield Township. That's not the false information about the process of voting. So this idea of falsity, this is not a falsity statute. This is a statute that prosecutes corrupt means or device that interferes with an elector's ability to vote. It doesn't require some, like, I think that the narrowing construction offered by the...
Can you slow down and just walk me through your argument on why, if I say, if you vote for Donald Trump, you're going to go to jail, and I know that's false, why that doesn't violate the part of the statute dealing with influencing an elector and giving his or her vote? Explain that to me.
Right. Thank you. Bribery, menace, or corrupt means or device.
I knew it was false, and I did it to influence your vote. And to
So
get,
the-
and to
the
get
corrupt-
any gain, because it makes me feel good if Donald Trump loses.
So
That's the gain I want.
So the corrupt means or device is the place where this would lie. So it has to be, because you have to be, firstly, have the intent to influence, deter, or interrupt. You've said influence. And it has to be then wrongful, and I have to have knowledge of its wrongfulness, right? So then the question then comes
No,
is...
it's false. I made it
I know,
up because I'm
false is
clever. I'm
not,
clever.
it's not, that's not the statute. The statute is corrupt. So the fact that I give you false information about candidates has no bearing. In fact...
That's
if you-
not it. I gave you false information about the legal consequences of casting your vote for Donald Trump.
What did you say?
I gave you false information.
I know, but what was the
about
statement about Donald Trump? I'm not sure why it's
Legal
relevant at all. If it
consequences
doesn't relate to the
of voting.
process of voting, it's not encompassed. The concept of what corrupt means
I
or
have to
device...
say, I see you as just diverting off in different directions.
Yeah, the
say it
statement,
again.
the statement he gave was, if you vote for Donald Trump, you will be arrested.
All right.
And I know it's false when I made it, and I did it to influence your vote, and I did it for the gain that it makes me feel good all over if Donald Trump loses. Okay? That's the gain. Any
If
gain.
you vote for Donald Trump, you will be arrested. Then it seems to me that insofar as you're talking about the procedure of voting, I mean, we're dancing around. I tell you, these seem like fanciful hypotheticals, and part of the
Keep going to
analysis,
the
but I'll come back
procedure
to it.
of, how do you get procedure of voting where it says to influence an elector in giving his or her vote? Isn't that who they vote for? Isn't that what the
But the
statute?
question is, what constitutes corrupt means or device? And corrupt means or device has to be looked in the structure of the statute. That's why I think the witness tampering statute is a helpful point of reference, because this is a statute. In fact, the word interrupt is not in the...
We interpreted that statute narrowly in our recent case, didn't we? People versus Wood.
You may have, but I think that my point, though, is that that was an effort of the
Look at that
legislature to
case.
come in and kind of make sense of what the common law was, and I don't think it's a codification, but it matches it. The question about what constitutes corruption and the... Because let's say I'm wrong. Let's say I can ensnare, then, the very thing you're saying, which I think is not true. I think this does relate to the processes and procedures of voting. So if you said you're going to be arrested,
But
that is a procedure...
I'm happy to hear your position on that. You just have to, I mean, why do you have that position? Can you explain it to me? Why, am I being unfair or unreasonable or not reading the English language properly when I read that one phrase? I'm worried about applying the concepts you're advocating under the other phrases to another. I have to read the whole statute as a whole, or should we just strike that line out or pretend it's not there?
No, because they have the three different possible forms, and the question comes is, when does falsity match up? When is falsity wrongful under corrupt means or device, such that it is encompassed within the
So
statute?
because we as a society are willing to accept lies by politicians and their campaigns generally about the other politicians and their campaigns, that's okay under this statute, but since we don't want to accept these despicable robocalls, it's a criminal violation? Is that the standard?
No, I mean, I think that the question, I didn't listen sufficiently carefully, I apologize for that about your Trump example, because you didn't then root it into the procedure, the actual
Trying
mechanism.
to
It
be
seemed pretty kind
bipartisan
of
and using
vague.
both sides as
Well, no, I
examples.
appreciate that, but the concept that the falsity has to relate to the procedure of voting, or to the
Why?
mechanisms of voting,
Why?
is inherent in the statute itself, insofar as what it's trying to achieve, which
It's
is...
language? The
It is
language of the
language. Give
statute?
his
What
or-
language is it inherent in?
It's
So that I
give
know.
his or her vote at any election. I mean, think about what the Court of Appeals said about this. The Court of Appeals was not plugged
Wait,
into this.
let me just stop you, because it says to influence an elector in giving his or her vote. And then it says, or to deter the elector from, or interrupt the elector in giving his or her vote at any election held in this state. So there's different concepts there, right? that the statute is designed to address.
Right. So under my reading, if you bribe someone to gain a vote, influence that vote, it's a crime. If you
What if you
threaten
make
someone,
a false statement about the legal consequences of voting that gives you any gain to
I
get them to
think
vote for your candidate or against the one you don't like? Is that a violation?
I think legal consequences, I would want a tighter phrase, frankly, but I think in my view,
They're
though.
trying to narrow you, now you're trying to narrow them? That's really,
Well, and I tell you this, I mean, I don't think I finished this point, and I guess to step back, and I'm gonna
Can you finish that point, and then
Sure.
we are going to hear
That
from
I
Mr.
think this,
Dolman.
that when you're reading about corrupt means or device, they're not talking about, this is not a statute designed to stop political debate and about who you should vote for, or why you should vote, not vote, in the abstract, or in terms of advocacy. This is about enabling electors to vote without being threatened, intimidated, or interrupted or interfered with. Starting with that premise, it then informs. So when I look at bribery and menace,
I know back in the old
They-
days, they used to have fights. There'd be violence often
well,
at the
if
polls.
in my thought is, if you had
You
a
know,
big
that's
guy
why
beating
this-
up a small guy because he didn't like the vote, that would be a crime.
What
We would
happened, the
charge him
stronger
without-
people at the polls controlled the polls, and they could intimidate people by making threats that they intended themselves to carry out.
Yes, but I don't think it would matter. It seems to me that if I say to you, when you vote, I understand that there are all sorts of people at your precinct, and I just select precincts that I don't like the way the people are voting in that precinct, and there are causing disturbances, or there's been an anthrax scare I give you false information about the actual procedure, the process for you voting. That, in my view, is a corrupt means which
If you
is
say, I
interrupting
think you
or
should
deterring.
vote, I think you should vote by absentee, because if you go to the polls, you might get the flu. It's an opinion, or,
It has to be false with the intention of deterring you from voting. We've already conceded that genuine warnings are not encompassed.
in
This-
deterring you from voting by any particular method. So if I'm trying to encourage voting by another method, but deterring you from voting by method A, then I violate the statute?
It is a part of the theory of this case, and one which I'm sure if we got to a jury that we'd prove beyond a reasonable doubt that the intention here wasn't just to stop by mail voting, but voting entirely. That was the real intention. I don't think there's any dispute about that, frankly. I mean, if you look at those internal emails, that's the full import of what's going on. So in your hypotheticals, if you have someone who is making a prudential judgment, even if it were inaccurate, it has to be both false and with the intention of one of these deter, influence, or interrupt the voting. Now, I'm coming back, though, to your question. You're saying, why isn't false information that influences? That's, I think, the question out of the box. Why is that not overbroad? The statute doesn't provide that. It says other corrupt means or device. But in context, other corrupt means or device isn't all falsity. It's only things that are relevant for the elector in the mechanism of voting. That's the proper construction of the statute. I think that's a common sense thing in the same way that if I had a voter, I had a witness who was going to be testifying and they were going to be subject to some kind of interference, I wouldn't say, well, if I tell him that the jury system is rigged or that juries don't believe people when they testify, you would have to be something along the lines that says they're going to arrest you when you come or they're going to hit you with only a $150 fine. These subpoenas aren't really, it would relate to the procedures. That's the very thing the United States Supreme Court has said in Mansky, of course, which is false information or misleading information about the procedures of voting is not constitutionally protected. This is not a speech statute, right? I mean, I know you're asking questions about...
Mr. Estucia, right here. I'm going to stop you. We've gone way over your time.
Oh, I'm sorry, I was
Yes.
answering questions.
And I think you answered, or
I'm
or
sorry,
attempted to answer.
I know I was way over. I apologize. I didn't mean to continue to go on without questions. I
I
certainly...
appreciate the arguments. Obviously, a significant case. Okay to go over time, and maybe we'll come back to you, but I think the Chief Justice is suggesting that it's time to hear.
From Mr. Dolman, yeah. Thank you.
Thank you.
Thank you again, Your Honors. So just a point of contention with my colleague from the ACLU. We have not conceded that false equals corrupt. I think we spent our entire brief arguing that false statements are not a corrupt means or device. I think with defining mean or device, we looked at definitions that use scheme or artifice, but we certainly have not made
Counsel,
that concession.
I like to keep it all simple. This has always been my thing. This is just how I like to focus. I think what this entire thing comes down to is that basically does this interfere with the process of voting? Not who to vote for, not how to vote, but it goes down to the process, information about where the poll is, information about what times you can vote, information about how you vote. And I think that's really what this goes down to. So at the end of the day, the contention that's being kind of put forth, again, just keeping it simple, right? The contention that's being forth is that your clients interfered with the process. The process. They said that there's going to be warrants that are going to be looked up. They said there could be mandatory vaccines. They said there could be past fines. The idea here was it wasn't designed to say vote for X or vote for Y. The whole idea here was that their goal in doing what they did with the call was to basically interfere and cause confusion and lie about the process and procedure. And that is all the Attorney General is basically arguing, is that you can say whatever you want about who you want, the way you want. But if you knowingly engage in a process that invades the integrity of the voting procedure, what is accurate and what is not, that is where the statute comes to play. Can you respond to that as it pertains to the specificity of what this specific robocall said?
I agree that a time, place, manner, false statements about time, place, and manner could be prescribed in the way the Attorney General has advocated for. The problem is it's not this statute, right? And I think it goes to the word I mentioned in the beginning, and that's influence, which makes clear that this is not just a statute about the mechanisms or procedure of voting. It's also about whom to vote for. So I agree that there could be a statute on the books about false statements dealing with time, place, manner. It's just not this statute, Your Honor.
Okay, if that's your contention, thank you.
Thank you. Which is also why the limiting instruction proposed by the ACLU is just not workable here. One thing about strict scrutiny and about whether any lower court has ever analyzed whether this is narrowly tailored, the burden is on the prosecution to show that a statute like this is narrowly tailored. And I think at their own peril, they did not make that showing at any court level. So I don't think it would be necessarily appropriate to remand this to give them another bite at the apple. Again, the Attorney General uses the word wrongful, and I still have not really heard an articulation of how this would apply to a case beyond this. And I think that comes into play with, or intersects with the First Amendment concern about chilling speech. Finally, I just want to mention I guess we use the phrase mundane mendacity inherent in American politics. I think what the kind of unspoken position of the Attorney General here is that, okay, fine, maybe under our construction it would reach that, but we're just not going to prosecute anyone for that. And I don't know if it was Scalia or someone else said that a rule that depends on the forbearance of prosecutors is usually not a good rule to have. So with that, I'm happy to answer any other questions the court has. Thank you, Your Honors.
Thank you all. The case will be submitted, and we are adjourned.